Good evening, Team Discovery, and good evening, colleagues. Welcome to this evening's webinar on the POPI Act, Protection of Personal Information Act, that was enacted in 2013 and will take effect on the 1st of July. Thanks very much to Morris Goodman for giving the initial go-ahead from Discovery's point of view and for partnering with us. Then I'd like to thank Larry Borowitz from Discovery for agreeing to do the presentation, and then Charlotte DeVos from Discovery for kindly facilitating, and then Anand Naika as well for co-facilitating the arrangements. Also Gqeberha Remy from the ECIPA Healthcare in Port Elizabeth for assisting with the arrangements as well. I'd like to thank my colleague Dr. Sean Falkwain for agreeing to introduce Larry Borowitz, and my colleague Dr. Gavin April will also assist in the background. Charlotte will assist with monitoring the chat and the questions at the end. Questions will be taken verbally, as well as if you're able to raise your electronic hand, Charlotte will monitor that together with Anand. I'm now going to hand over to Charlotte DeVos to make some introductory remarks from Discovery Health. There we go.
There you go. Thank you so much, Dr. Gqeberha. And again, thank you from our side as well for allowing us the opportunity to be part of your meeting this evening. I think from our side, from Discovery's side, we have been facilitating a series of webinars over the month of May. And this is in support or as an attempt to support our healthcare professionals as we near the end of our 12-month grace period. Course from the 1st of July 2021, we need to make sure that we are all compliant with the Protection of Personal Information Act in its entirety. And therefore, from the 1st of July, information sharing between health professionals and the funders must comply with the Act, and the regulator can then exercise their enforcement and powers as per the Act. And therefore tonight we welcome you, and we would like you to raise any questions you might have as Larry goes through his presentation. Please make use of the chat like Dr. Gqeberha indicated. Myself and Anand will then coordinate these questions, but we will also allow and take some questions live as we get to the end of the session. We do ask that if there's any other questions that doesn't pertain to the topic, please can we try and limit it to the topic just so that we don't take too much of your time this evening. Larry's presentation will then be about 35 to 40 minutes, after which we hope to spend another about 20 minutes on the question and answer session. And then I'll hand over to Dr. Falkwain to do the introduction. Thank you.
Sean, before you come in, I see Dr. Ramsabag has got his hand up. I'm not sure whether that's intentional hand or he's got Erb's palsy. Sean, I'm going to try and find you. Oh, there you are. Okay, just need to get you to unmute. You can unmute, Sean.
Okay, I think I'm live.
Yes, you are.
Am I there?
Yes, you're live.
Okay. Okay, good evening, colleagues, and welcome to our meeting this evening. I'm going to introduce the speaker for tonight's meeting. So Larry Borowitz, he is from Johannesburg, South Africa. He has university degrees in information systems and is a certified Lean Six Sigma Master Black Belt. Now, originally I thought this was he had karate experience, but it seems like it's more to do with lean thinking methodology. I just looked that up now. So Larry has been employed by Discovery Health since 2003. He's currently head of Service Lab Operations Management the department responsible for governance programs and enabling process and service optimization through measuring and monitoring key service metrics. He is a Deputy Information Officer designate for Gqeberha Health and has been responsible for, among others, the company's quality management system and Treating Customers Fairly program. In his career, Larry has garnered a wide array of management systems and consulting experience through the positions he has filled in his various capacities at consulting firms and at some of South Africa's leading technology companies. Larry is married and has 3 children. So we're looking forward to hearing from Larry Borowitz. Thank you.
Thank you so much. Thanks for the warm introduction. And thanks to Dr. Gqeberha and all of his colleagues for the opportunity to present to the ECIPA Healthcare Forum. In terms of the Protection of Personal Information Act, you can see that on the screen I've called it POPIA, but sometimes we call it the POPI Act, sometimes we call it POPI. So during the presentation, you may find that I may interchange the different descriptions of, in essence, the...
Larry,
yeah.
you need to share your screen.
Is it not showing? Sorry.
Yeah, remember I shared.
Yes, is it showing now?
Let me see if you got permission. Yeah, you do have permission.
Can everyone see that?
No, not yet. Not yet. It's coming up. There we go.
Okay, so let's carry on. Okay, so you can see, as I said, it's says Protection of Personal Information Act, so it's POPIA or POPI or the POPI Act. So we interchange those descriptors in terms of the Act, which is now being enforced to ensure the privacy protection across South Africa. So in terms of the status of the Act, so as Dr. Gqeberha said, the Act was initially signed into law by President Zuma in November 2013. And it's taken a very long time to get us to the point where for the 1st of July, the Act's going to be fully effective and enforceable. So what's been delaying the enforcement of the Act? So I think the first thing to maybe point out is that an information regulator needed to be appointed. And she's been appointed effective 2016. And her name is Panzi Ntakula. And you may remember her from the Independent Electoral Commission. So when she was appointed, she then had to draft additional regulations to support the enforcement of the POPI Act. So she then published her regulations in 2017, quite near the end in September, and then they had to get public comment. So there's been quite a bit of toing and froing in terms of formalizing her regulations to ensure that the Act is enforceable and can be monitored and regulated from the date that it is fully effective and enforceable. So I think to a lot of our surprise, last July, President Ramaphosa then, in essence, said that all sections of the Act will come into effect, and he gave us a 12-month window before we needed to be fully compliant. So 1st of July is literally now around the corner, where we now need to make sure that we are going to be compliant with the Act. And the regulator is going to play her role to ensure that she'll monitor the compliance across the country. So who are the role players? So the first is, as I said, the information regulator. Then within each private or public body, there is what they call an information officer. And this information officer can appoint what we call deputy information officers. And I'll go into more detail around that role. But the whole idea is that within an organization, the information officer is the person who liaises with the information regulator around all matters relating to privacy. Then we have the data subject. And the data subject is an identifiable person or a juristic entity. So a data subject can have 2 types of information associated to it. The first is what we call PI, or personal information, and the second is a special type of personal information which we refer to as SPI. So this person or entity can be an employee, a customer, a shareholder, a prospect, and any information like name, surname, cell phone number, email address will be associated to that data subject. Special person information relates to information for, in terms of children, one's religious beliefs, one's race, trade union membership, one's health or sex life, biometrics, and other things like criminal offenses. So then the data subject then gives his or her data to a responsible party. So just from a definition point of view, a responsible party is any public or private body or person that determines the purpose of and means of processing of personal information. So in our context this evening, we're going to talk pretty much around the healthcare practitioner as the responsible party. And the responsible party is required to have their own framework, understand how they want to classify the information, how they retain it, what access they provide, etc. And you can see on the right in that speech bubble where it says conditions for lawful processing, there are 8 conditions which exist in the Act. And that really is the essence of POPIA. But what we've seen in Discovery is that many people don't relate to the kind of legalese and the legal terminology and the structure of a piece of legislation. So what you'll see throughout the presentation is what I'm intending to do is to show you how we've tried to position POPIA differently. And then the majority of the presentation is really to position how POPIA affects you as healthcare practitioners. But just to say that those 8 conditions, supported by those extra conditions at the bottom of that speech bubble, are required in essence to ensure compliance with the Act. And then the last role player in terms of this diagram is what we call an operator. And the operator, again, if you look at the definition on the top, is any person or party that processes personal information for a responsible party in terms of a contract or mandate. So in terms of a health practitioner, a good example would be a bureau, where the responsible party would sign a contract with that bureau, who then operate on their data with direct authority. So that really sets the scene in terms of the role players. I think what's important and what I want to do now is just explain how this works in terms of the health practitioner environment. So I'm just going to quickly get my laser pointer just to make this diagram a bit more understandable. So let's look at the healthcare practitioner who's sitting here in the middle. And the healthcare practitioner can have different relationships with different parties. So let's start with the patients. So the patient would be a data subject who then contract with or give direct consent to the healthcare practitioner as a responsible party for their data. Then the healthcare practitioner can appoint numerous operators to act on his or her behalf. So let's have a look at, for example, a B2B provider or a PMA, where the healthcare practitioner will sign a contract with that PMA or B2B provider to operate on their data. We can see the healthcare practitioner can also appoint bureaus to operate on their data. And then in the terms of other third parties, to use the example of a dental lab, the healthcare practitioner can appoint the operator to whom they're going to pass personal information or special person information where that particular data subject doesn't have a direct relationship with this third party. So a dentist, for example, may take an impression to make a prosthesis for a patient, but the patient will never actually interact with this dental lab in terms of being able to consent to the sharing of any information. So you can see here the healthcare practitioners, in essence, what I've given here are 3 examples of where they are an operator and where they're acting as a responsible party. Then in terms of medical schemes, let's have a look at the relationship. So there we have a data subject who would be a member of a medical scheme. So in the case of Discovery, our members would give us the consent to be the responsible party for their data. Then the medical schemes like Discovery Health Medical Scheme will appoint Discovery Health as an operator in terms of being an administrator or managed care provider of that particular medical scheme on behalf of the members who've given the medical scheme the role of responsible party. Now, what does it mean in terms of the relationship between the healthcare practitioner and other parties and medical scheme administrators like Discovery Health? So what you can see is the lines here are dotted. And that's done intentionally to show that the relationship is not one of a responsible party or an operator, but more one of an independent party for data collection in the case of, for example, PMAs, where the doctors appointed the PMA and the PMA then submits claims to Discovery Health to process on behalf of the patient, or its members. But we do recognize that there will be scenarios where the doctor wants to share information with Discovery, or Discovery wants to share information with the doctor. So for example, the doctor may want to ask a certain question to a Discovery doctor. So they've got a patient, they've got a difficult case, and they'd like to get more information, discuss the case. So in this scenario, the healthcare practitioner can share this information with Discovery because they would have got consent from their patients to share this information. At the same time, Discovery would then share information back to the healthcare practitioner because Discovery would have received consent from the data subject as a member in its capacity, in his or her capacity, in terms of granting that consent to the medical scheme, and then the operator will then be Discovery Health. And if we look at the bureaus, for example, Discovery doesn't have a direct contract relationship with the bureau, but it will share information with the bureau in terms of providing information about the healthcare practitioner and its members in terms of, let's say, for example, claims that need to be paid. So that just sort of tees up the environment in terms of where doctors, patients, and medical schemes and medical scheme administrators fit in terms of the broader healthcare practitioner environment. Then what we also did in Discovery Health is that we said, because we found people don't relate to the legal structure of the Act, we said, let's think of a different way to represent the information. So what we've done is we've kind of thought of it in terms of like a house, where you'd have the Act itself, which would be the foundation. Then we'd have what we call cross-life cycle considerations, which would act as beams to support the different pillars, which would be acquire, use, share, and maintain during the life cycle of data. So we have our pillars, we have our beams, and we have our foundation. And what's really important is, in terms of what we found, is that people like to think about data more from a life cycle perspective, or how does the data life cycle work from a process perspective. So in terms of the first phase is acquisition of data, then use, then sharing and maintaining. And the principles sort of sit in the middle, and these principles are embedded in the Act. So during my talk, I will refer to some of these principles. But in terms of the structure of the presentation, I'm going to be using some of the different pillars as well as the different pillars as well as the beams to talk about POPIA. And another element of the Act, which we also brought into our framework, is the ability to log incidences that members of the public can complain, and if complaints are warranted, that there be breaches, and that would then be taken forward by the regulator. So this really kind of is our framework which we've adopted internally, which we're happy to share, and which we're finding is working in terms of just our own staff and people we're speaking to, kind of getting a sense of how we view POPIA and how we can assist the likes of yourselves tonight to deploy POPIA successfully in your practices. So let's look at what we call definitions, nominated individuals, and parties. And the first point I want to touch on is that first point on the left-hand side, which is what we're saying is that there's obviously the law and the legal imperative to comply with the Act in terms of the letter of the law. But what we're saying is the spirit of the law is such that the Act is principles-based and supports the right to privacy and how this should be protected. So really what we're saying is we believe we should be not only supporting the Act because it is the law, but in essence because it's the right thing to do. And what we're finding out and seeing in the market is that because the Act is principles-based, it's actually quite broad, and it enables the deployment of the Act to suit the organization, provided it complies with the Act. But we're starting to see that a lot of people are starting to get quite anxious about sharing data effective 1 July. And what we're trying to convey in our communications is that business needs to continue. And the Act is not there to sort of, from the 1st of July, kind of shut down any sharing of information between different parties, because that's really what business, medicine is really all about. It's about sharing information between different parties. So I think it's important that, yes, there is the law and one has to comply, but because the Act is really about the intent to protect people's privacy, that really should be considered all the time. And we shouldn't become overly anxious about sharing data as long as the fundamentals are in place in terms of deploying the Act and then complying with the Act. So in terms of the role of an information officer, the head of a practice is by default the information officer. So by that I mean that if you have, for example, a practice with 10 doctors and you have a head doctor, then that person would be regarded as the head of their practice and then would be the default information officer. But that person can appoint other individuals, first of all, in the guise of an information officer, so there'd be one of those, and then that information officer can appoint additional deputy information officers. So if you have quite a large practice and you want to appoint, for example, your practice manager as an information officer, and then you want other people to also be involved in privacy matters, you can then appoint deputy information officers. So as things stand now, there's forms available on the regulator's website. We're still waiting for the actual URL of the website to start capturing information officers, but there is a web address, an email address that you can send your completed forms to at the moment. But we're hoping in the next week or two that the regulator will actually open up the URL, and then you'll be able to go in and capture your information officer information. In terms of the impact of POPI, what we're seeing is that in cases where privacy complaints are lodged, the regulator could prosecute, and the court will be able to award damages for monetary and non-monetary loss, or aggravated damages, or interest, or even legal fees. And I think what they're trying to do from an Act perspective is to say that they actually be taken seriously, and that the information officer, or in this case, the head of a practice, could be jailed for up to 10 years, and fines of up to 10 million rand could be awarded in the case of a breach. What has been happening over the last 12 months is that the regulator has not issued any fines, but we'll start seeing from 1 July how they want to deploy their regulations and how they want to enforce the Act and make sure that potentially they sort of go investigate different scenarios where there have been complaints or incidences logged and potential breaches. And then we could start seeing fines being logged and awarded by the regulator against certain organizations. But at this stage, because the Act is obviously not in full force, we don't have any idea of what the regulator is thinking in terms of fines and sort of punishing people who transgress the regulation. So let's look at some of the elements of the Act. So the first is around storage and security. So what we want to do is ensure the integrity and confidentiality of information securely. And there's two elements around this I just want to touch on. The first is physical access to files. So in any practice, you're going to have your folders, your files, which are stored in cabinets or in big cupboards. And what you need to make sure is that access to those files is understood or protected. And only certain individuals who've been designated with responsibilities who actually need to access those files should be going to take those files, potentially reading them or looking at them or acting on them. So it's important that there's physical protection of the information embedded in those files. The second is around information being left on a desk about a patient which is visible to another patient. So a good example, for example, would be if a pathology test comes back and the doctor's busy reading it on his desk and it relates to patient X, and then patient Y comes into the doctor's rooms and sits at the doctor's desk and then sees that pathology report. And X and Y actually know each other. So that would be quite a breach of information where Y's information would have been visible to patient X. So what we're saying is that you need to have like a clean desk policy and start thinking about trying to limit the amount of information that is left lying around. And certainly that at a reception desk, on a doctor's desk, or any scenario that exists where you can potentially see other information, that it's not visible to anybody else who shouldn't have rights to it because it's not their information, or consent's not been given to the person who's looking at that information. From a physical record perspective, these should be disposed of professionally. So you can't, for example, take old files and records and throw them in the bin without shredding them. So you need to make sure that when you're disposing of information, the information captured on those pages cannot be read by someone else if they had to pick them up, for example, from a garbage bin. And the information should be invisible in a way through shredding. And then computer systems must have the necessary security and cybersecurity controls in place. So this is the typical scenarios we've seen over the last number of years where computer systems have been hacked and there's sometimes been millions of records which have been compromised. So this is a key control of personal information, and the types of things you need to look at in terms of your practices would be looking at your own PCs, making sure they've got the McAfee protection software on them, that your networks are protected, that you've got firewalls in place, and that your computer infrastructure is secure, and that you've limited the ability of potential hackers to access any information on your systems. And then, for example, if you're using cloud software, that you need to make sure that you also got the right controls in place. And a key element of this would also be around passwords and not sharing of passwords. So it's definitely going to be a key requirement going forward that individuals must protect their own password, their own information, and not share it with other people, for example, in an office. So we shouldn't see a practice manager having one password which is being shared across multiple people. Because if there is a breach of information, then who would then be held accountable? In terms of acquisition of data, the first thing I want to touch on is patient registration forms. So let's take the scenario where a new patient comes to your practice and they fill out that form where they say, yes, they want to be a patient of yours. So the first comment would be around this concept you can see on the screen of minimality. And what minimality really is about is saying that when you are acquiring information about a patient, you need to make sure that you're capturing the minimum amount of information which you need for the purpose that you're being appointed. So if we take, for example, a patient joining a practice as a patient, you would need to know certain information which would be clinical as well as administrative. So if you think of administrative information, we could think of like their billing information or the email address to send their statement to. But for a doctor to treat a patient, they don't need to know their income. So in this case, if you were acquiring income information from a patient, the regulator could say to you that you're breaching that principle of minimality because you're getting information which is actually not relevant to the purpose for which you have been appointed, i.e. as a practitioner to treat patients. Then the second element is what we call a privacy statement. And this is probably the most important document in a practice or in any organization. And what the privacy statement is all about is ensuring that there's an understanding of the purpose of why the information is being collected. But what it intends to do is to protect the patients or the data subjects, as well as the responsible parties and the operators in terms of their rights and their limitations. So the privacy statement could be a short document or a longer document, but it should include all the different elements which are important to the practice in terms of how they see the protection of information and what they're trying to do in terms of protecting their patients and their information. So what we've done in our Discovery Health, and this has been at the request of some of the practitioners, is we've created a guideline template where we can send this to people on this call. You can speak to your account manager. And what we're doing is we're saying, here is the guideline or a template, which includes some of the clauses which we recommend you would include in your privacy statement. And we're suggesting that as a start, you send out a privacy statement, which can be seen by a legal practitioner as well, just to kind of make sure that they and you are comfortable with it, but that you send it out to your existing patients to say, this is how we want to protect your privacy as well as our rights in terms of looking after your data. At the same time, what we'd also recommend is that you re-look at your patient registration forms and you incorporate some of the clauses from your privacy statements into those patient registration forms, so that for all new and future patients, you've covered yourself in terms of the different POPIA clauses, and that all the different elements around privacy and protection of personal information have been covered for those new and future patients. So again, we'd say, like, once you take your privacy statement, extract some of that and put those into your patient registration forms for new patients. The third element is around consent. And this is where you need to make sure that you're granting consent to the responsible party to share your information or to use your information in a certain way. So while this is so important, if you think about different scenarios, and we'll use that of a family. So in terms of consent, you can set up your registration form, your privacy statement to say that when, let's take a family of 5. So we get the husband coming in and he joins your practice, but he's got a wife and 3 children. So that particular husband would then say that he's consenting to the doctor to manage and look after his personal information, but he can also say that he's granting consent on behalf of his wife as another adult. Now, you'd have to include that in your privacy statement to say that is how you manage consent within your practice. because the regulator is looking at making sure that every adult is aware of their rights and that they grant consent. But we all know that the medical industry is quite different. So, for example, in discovery, you get the principal member and then adult dependents. So what we're saying in terms of practices, you can also look at a first person in terms of joining that practice who could sign consent on behalf of other adult dependents and then on behalf of children as well. And then there are also scenarios where you need to grant consent for individuals without capacity, for example, someone with dementia or some kind of other illness where they cannot act in their own capacity. So I think this is a very important part of POPIA. And if you can get this right, it takes you a long way to making sure that you are protecting information and there's a good understanding of what your rights are and what the rights of your patients are as well. In terms of using information, there's two concepts I want to touch on here. So the first is what we call original purpose, and the second is further processing limitation. And what these concepts are really saying is that when you gather data initially from a data subject, you can only use it for its intended original purpose, and there's limitations on further processing of the information. So if you think about, let's say, marketing, where a marketing company comes to your practice to say, please, can you sell us your data? What we're saying is that when you're acquiring the data, you are acquiring it for the purposes of, in the case of healthcare practitioners, treating patients. You're not there to acquire data to sell it on to other vendors who work within the marketing sphere. So if you, for example, say, right, I'd like to sell this data because I believe it's got some kind of value, you have to get consent from your patients to sell and share that information. You cannot use it for any other purpose, as I said earlier, in terms of like other than the original purpose for which it was acquired. The next thing I want to just touch on is around information quality. And this is where we're looking at how to keep the quality of the information you have on your systems up to date. So what we're recommending is that you maybe do a campaign with your patients now using POPIA as that kind of framework and the trigger to say, we are re-looking at our quality of information. Please, can you update us with any information which may have changed over the last while so that we have the latest information about you on record. And at the same time, there is the onus on the practice to make sure that the administrators update information as and when it's provided by patients. Then the next element around use is this concept of openness, where the whole question of what can the patient see and how open is your information in terms of their information. And what's important in terms of the Act is that the Act says that all processing operations on patient data should be stored and available. And patients also need to understand the consequences of not providing updated information. So if, for example, a patient goes and sees a specialist and then they go back to their GP, they need to make sure that they update their GP on the diagnosis of the specialist. Because if they're expecting the GP now to treat them and they've been diagnosed with a certain illness by that specialist, if they don't give that information over, they cannot expect the practice or the practitioner then to do the best job they can because they would be lacking information. And there's also a scenario where, for example, next of kin information is not provided, where it could land up where a decision needs to be taken, which could be a life and death decision, where you do need next of kin to assist, and the information that is on record is out of date. So this whole question of keeping information up to date is definitely going to become a big thing in terms of privacy, and it's two-sided. So it's not just the responsible party who needs to keep the information up to date, but the data subjects also need to understand that there's an onus on them to also keep the information current. In terms of sharing, communicating information, the first thing I want to touch on is around third-party contracts. So I touched on that dental lab example earlier. So what we're proposing, and if you look at the bureaus and practices, etc., is that practices go back and look at contracts they have where they believe there could be some kind of POPIA-related clause required or clauses required. So if, for example, you've appointed a bureau to manage your data and your accounts on behalf of your practice, that would definitely be a scenario where you need to have a formal contract where POPIA clauses would be relevant. So if you're at this point where your contracts maybe don't include POPIA-related clauses, we're proposing that you go and re-look at your contracts and then get them updated with POPIA-related clauses. The next element is around external communication. And this is quite a big one, because this is really where you have emails, you have other types of scenarios where communication is going between two different parties out of your practice. So the first thing we're saying is that you should have policies and procedures in place to limit information being shared with unintended parties. So you need to think, how do I limit data going to parties who I don't want to share this data with? So what we're recommending is that you use security features in email applications where you can encrypt emails. You can also encrypt PDF documents, and you can also create what we're calling secure inboxes. So what we from Discovery are looking at doing in terms of our relationship with our healthcare practitioners is we want to set up secure inboxes where the information which we're sharing with you will go into these secure inboxes, so we know that they'll be going to a place where only people who've got some kind of access through a username or password will be able to access that information. So if we look at, for example, Discovery sending information to a secure inbox, what we want to sort of propose with all of our different practitioners is that they get logins on our HP zone, and that the different roles which are played in the practice would then be given consent by the doctor or the doctors for those people to have access to information. So that person would register on our HP zone, would get a secure password, and they'd have a username. So when they want to see information, they would then log in and they'd see information based on their role and profile in a secure inbox. What we also will be doing in certain scenarios is encrypting PDFs. So currently when you send out a PDF, you can open it without putting a identifier or a keyword in. Certainly for our members, we're moving to a world of secure inboxes, as well as encrypting some of our PDFs. So for example, the daily claim statement or daily claims notification will be encrypted. So if inadvertently it goes to the wrong recipient, then that recipient would have to know the ID number or the birthday of the intended recipient or data subject. And the third element around sharing is the information being shared outside the borders of South Africa. So the government, and through the Act, wants to limit information being shared outside the borders of our country. But what we can say is that there are scenarios, especially for medical practitioners, where they would have discretionary authority to share that information. So if one of your patients is overseas and something happens and you get a call from a hospital or another specialist or doctor, you'd be able to share the information you have about that patient to ensure they could get the best medical treatment required when they're not in your care outside the borders of the country. So I think medical practitioners would have quite a bit of flexibility, and they could use their discretion around sharing information as and when required in cases of emergency. And then in terms of maintaining and managing data longer term. So the first thing one needs to be able to do is delete or de-identify information. So a patient comes to you and say to you that they don't want you to have any record about them on your systems or in your files. So they will fill out a form, which has been designated by the regulator. They will then send that form to you. And then the onus is on you then as the practitioner to delete or remove or de-identify any information you have. So by de-identifying, what you're saying is you can keep the information, but you should not be able to identify that member or that patient through the information you have on record. So you, for example, want to say, I want to keep a trend of what's happened with all my patients in terms of, let's say, HIV over 30 years. What we're saying is that if some patients have died or they've left your practice, you may want to keep that information, which you can do, provided there's no ways to re-identify in a way information once it's been de-identified. And there should be no way to associate an individual or a data subject to that information. The next element around maintenance is a retention policy. So your practice needs to decide on the time frame to keep patient data. And what we've seen is that the HPCSA, in their guideline for good practice, in their booklet number 9, it's called the duration for the retention of health records. What they're proposing is that practitioners keep information for 6 years as a sort of a standard. But your practice can decide on its own right to keep information for longer, as long as you can justify why you do that. So typically what will happen is that from the time the information becomes dormant, or the person passes away or leaves your practice in terms of being in your care, you could say we've got 6 years to keep that information relating to that data subject. But after that, you then need to remove that information from your records. And there's also other specific laws for retaining medical information, for example, the Children's Act and other acts, which can also influence how long you keep information for. And the last element around maintenance is to think about your data from a structured and unstructured perspective. So structured data would be anything which would typically be sitting in a database like name, surname, email address, ID number, etc. While unstructured data would be your patient notes, your emails about patients, any other information you may have in terms of files or notes or information or communication with Discovery, for example. So if a patient comes and says to you, they want you to delete or de-identify the information, you need to what we call, and it's not our term, it's actually an industry term, do data discovery, which is go and search through all your data and say, you've done everything in your power to remove information, which is both structured and unstructured from your records. So what is Discovery doing to support healthcare professionals? So there's 3 tools I want to talk about tonight. So the first is the Connected Care platform. So this is a secure, enhanced platform where you can secure practitioner consultations. So the way the platform's working, and some of you may have used it, but the idea is that you can either book a virtual consultation with a practitioner or you can book a physical consultation. But the idea is that we kind of helping the world of digital medicine kind of take, which we started seeing last year when COVID came in and we needed to find other avenues for people to start interacting with their practitioners because physical consultations weren't really possible or were limited. So we've now kind of invested in this product called Connected Care, where we want to try and assist patients and practitioners to connect both physically as well as digitally. Then Health ID, I'm sure many of you are using this. So there's 3 key benefits or advantages we see around Health ID. So the first is secure login to access patient information. The second is around getting consent from data subjects or your patients so that they can consent for other practitioners to see their medical information. And then also the storage of information in this clinical data repository, which is a secure patient record store in essence. So Health ID is becoming, again, another core element of our strategy in terms of enabling practitioners to have secure logins, get consent, and then have information shared amongst themselves in terms of the practitioners. And I think we all know, for example, radiology or pathology tests shouldn't just be shared potentially with one practice, but once they've been undertaken, you can share them across multiple practices, and Health ID obviously is enabling that. And then the provider zone, which I referred to earlier, which is the website where you can log in and access practice and patient information very easily. And that's what we really want to drive with practices so that different roles in the practices can then have logins to access information. So to bring it all together, we've put together a 10-point checklist, which is really sort of a summary of what I've spoken about. And we believe that this 10-point checklist can assist you with POPIA readiness. So we're saying it's not the panacea to compliance, but it's certainly 10 points to consider to assist you with getting ready for the 1st of July. So the first point is around appointing an information officer. So either you can, if you decide to be the information officer and not appoint anybody, then register yourself with the regulator, or then go through the process of appointing another information officer and potentially other deputy information officers in your practice. Then from an access to information perspective, what we're saying is that you should look at the access people have in your practice to patient files and make sure that these are secure and they can only be accessed by designated staff, and that you've looked at your computer systems and you've got the right controls in place to ensure access only by authorized individuals. From a privacy statement perspective, you should create a privacy statement if you haven't got one already, which includes these POPIA-related policies and clauses, and these should be shared with existing patients. Then we're suggesting you update your patient registration forms to include these privacy statement clauses, including those relating to consent. And again, look at that concept of minimality to ensure you're only obtaining information which you actually and only need for the purposes which you're going to be appointed in terms of a healthcare practitioner servicing a patient. Then you should look at your information quality and look at what your patients have provided, request them to update their details, their biographical and contact details, and then you should then update your records. Then from a retention perspective, you need to look at what policy you have in place and document this around what your policy is for how long you keep records. And it could be, as I say, 5 years, 6 years, 7 years or longer, and then just explain why that is the case. And then if you do have information which is older than the stipulated period that you keep information, then you need to go and delete and dispose of that. Then from an accessibility point of view, you need to look at all your information and make sure that patients can access that information. So an adjunct act to POPI is a PIA, or Promotion of Access to Information Act. And these two acts, in essence, you could call them sister acts, where POPI is really about protecting information and PIA is about the ability of data subjects to access the information that responsible parties have on record about them. So a patient can come to you and say, I want to see all the information you have about me, and I'm using the PIA Act as the tool to access that. They can then again fill out a form based on the PIA Act, and then you as a responsible party may have to give them all the records in terms of your patient notes, your other stuff on the databases that you may have, any other information to share, which you could share with a patient, you would have to share with them. Then from a third-party contracts perspective, again, it's about those third-party contracts, looking at them, making sure that where relevant, they do have POPI clauses or POPIA clauses in them, and that you update them to make sure they're ready for 1 July. From an external communication perspective, look at your policies and procedures around external communication, and make sure that you have got the right technology in place to support your strategy. And a good example is that you're going to encrypt your documents. And last but certainly not least is the training of your staff, and just not giving them in-depth training on POPIA, but just making sure that the fundamentals are in place, they understand some of the points in this 10-point checklist, and that good behavior like not sharing passwords or keeping desks tidy become part and parcel of the way the practice operates on a day-to-day basis. And on that note, I'm going to finish the formal presentation and stop sharing, and then we can go over to questions.
Thanks very much, Larry, for that most interesting, informative, and clear presentation. Highly appreciated. So we're going to open
Pleasure.
up. Yeah, thank you. We're going to open up for questions now. Just to remind all the attendees that Dr. Sean Falkwen will post the online register link. It's probably posted. Sean, I think you should post it now. And please, if you would like your CPD certificate, please click on that and complete the register. I'm going to hand over to Charlotte. I think there's some questions in the chat. I have some questions as well, but I'll let Charlotte go first. Are you able to unmute?
Dr. Gqeberha, just one other point, just that we have my colleague, Dr. Peter van der Walt, who's turned his camera on, who's also in the webinar. So he'll be taking also questions from the audience.
Welcome, Peter. Thank you for joining us.
Great, thanks, Larry. Yeah, I was going to say Dr. Peter van der Walt has joined us. He is our Information Governance and Privacy Officer at Discovery. So yeah, just any additional questions or any questions that might be posed at him. Larry, I think for now there's only been one question in the chat that is around data storage. So basically the question was, how is the deletion of information? How does that affect or how is that affected by POPIA?
So I think a key point around this is that we don't want to compromise the integrity of data in any business or any practice. So you can't sort of go into the database and just delete a record and kind of take away all the referential integrity of the records that exist. So what we've done in Discovery, we spent a lot of time looking at options to, in essence, find a way to hide or remove visibility of that information. And there are ways of doing it with databases in terms of sort of looking at records and making sure that only that records are not visible to different parties in a business or in a practice. You know, deleting data can be quite dangerous, but I think what we're looking at is more around the fact that we want to de-identify people who come to us to request that information is not visible. You know, in terms of deleting, it is quite a difficult practice to do from a technical perspective. So what we're proposing is that people look and say, certainly data which is physical, that can obviously be deleted, like records which are older than 6, 7, 8 years, depending on your period of retention. So those should be deleted, but certainly more technically stored information, you need to think of and find ways from some software vendors to find ways to, in essence, hide that data so it is no longer visible to anybody in that practice. I'm not sure, Peter, if you want to add anything to that.
Yeah, no, thanks, Larry, and good evening, everybody. So as I read the question, it also says there in terms of history, insurance, and lawyers, etc. So the conundrum here is that if there's a request or a request for information from a third-party lawyers for some investigation or even some institutions, post the 7 years, is what position does that put the practice or the company in? So we are looking at a clause in the Act that talks about legitimate purpose to keep that information for longer than your retention period. So that's something that we're busy taking, taking a bit further in terms of investigating that. But in the main, if your records are no longer required, it's served its purpose, the patient or the client is no longer a active participant in engaging with yourselves, and the 7 years has expired, there should be no other reason to keep that information. So as Larry said, there is danger in deleting the data, but there's also danger in keeping the data. So if there's theft or if there's a breach on systems, etc., the data leaks out, you are still responsible for answering to the regulator as to why no controls were in place or insufficient security controls were in place, or why have you kept those records for longer than what's intended. So it's a balancing act almost to take into account, what do I keep, what don't I keep? If I delete it, what is the impact? If I keep it, what is the impact? So the Act says delete the information once it's no longer needed for the purpose that it was collected for. So that's what we say. 7 years after that, the last interaction with the patient or the member, the clock starts ticking, and if there's no interaction during that 7-year period, we de-identify that particular record.
Peter, what about for malpractice situations, like in children? You're expected to keep it for a substantial amount of time, and if 10 years or 15 years post the scenario, you get called up for malpractice, and then you don't have the records. What about that?
Yeah, that is like I said, that is the conundrum. So is your decision to keep records maybe for 15 years, and then make sure that there's something substantial that you can fall back on to say, our retention period for this particular practice is 15 years, for argument's sake, and be able to substantiate that type of retention period as well. I mean, in our case, we follow the Companies Act as our guideline in terms of retention period, but we've also made provision that should during that period a litigation matter or a forensics matter come up, we would not do anything with that record until that case is closed, and then we also apply 7 years after that particular case. But ultimately, it's a decision that also has to be taken in your practice to say, if there's a chance for malpractice come up for this particular event, we decide to keep our records for 15 years. I believe the HSPCA also have some guidelines in terms of records retention, and there's also guidelines that you can follow in terms of what's practiced can be followed in those guidelines.
Thank you.
And Jeff, for example, I'm thinking of, it's like an obstetrician, for example. I think it would be a good example. And the way I'm looking at the Act is that if you can justify why you keep those records for longer, then that can be your policy, and you can state that as your policy.
Yeah.
Great. Neil Bloom, your hand is up.
Can you hear me, Jeff?
Yes.
Right. Thanks for giving me the chance. The specifics would be insurance companies requesting records of previous visits. Of course, just for the purpose of covering those individuals, you wouldn't know in advance who's going to require that, so that this will come out of the blue. So in terms of the lawyers, you would know that the records that refer to, for instance, an MVA, you'll keep those records. But to de-identify records makes them basically null and void. I mean, it might mean, I suppose, you can put it in a different vault, but you will have to keep the identification on it. Otherwise, it can't be linked to anybody. And then I would suggest for the obstetricians, they would know that, say it was a difficult pregnancy or difficult birth, that there's possible, because as far as I know, they have to keep records of their records for 21 years at the very least. And we were always told and taught that the medical records are for life. But if you could answer some of those questions, thank you.
In the HSPC, sorry if I get the abbreviation wrong, there is provision for certain types of records around mental health, and I can't remember exactly others, that you have to keep those for life. That's definitely stated in those guidelines. I'm just trying to quickly get to those guidelines, but there is specifics where it talks to those type of situations or scenarios. HPCSA, sorry. There are scenarios around, I'll just quickly get that. So that at least that's documented within your retention policy, and reference is made in your privacy statement to say that where we do have to retain records, it would be guided by legislation or HSPCA guidelines, etc. Just quickly, records keeping.
And I think just my view is that, provided you can justify why you retain data for a certain period based on the nature of your practice or your business, I can't imagine that the regulator would object if you can justify it. So if you, for example, like an obstetrician or a psychiatrist, look at your practice and the typical relationships you may have with a patient over the lifetime of that patient, where you may be requested in a court case or some kind of other scenario to share that information, then it would not make sense to de-identify. But as I say, as long as you can justify your retention period, I certainly think the regulator would look on that quite favorably, especially from a medical fraternity perspective. So I honestly don't think one should get too hung up about the retention period based on the nature of the business or what the medical fraternity and the world of medicine and treating patients.
I've just pasted or copied into the chat box a reference from medicalprotection.org, where they make reference of the HPCSA's guidelines for keeping of patient records. And there it talks to records should be kept for at least 6 years after they become dormant. Reference to children, minors, up until their 21st birthday. Patients who are mentally impaired should be kept until the patient's death. So these are long terms that you should be considering as part of your retention policy, at least. So there's some guidelines that one can follow, at least to make sure that you within the specific guidelines when it comes to retaining that document for the appropriate period.
Thank you, Peter and Larry. Lester, I see your hand is up. If you would like to speak, you need to unmute. If not, I'm going to hand over to Charlotte. Okay, Charlotte, over to you. Are there more questions? Let me help you.
Oh, there we go. Sorry, I thought I did unmute. There hasn't been any more questions in the chat so far. I don't know, Dr. Ramsubach's hand's also been up the whole time. I'm not sure if he had any question.
Yeah, his hand has been up since the start of the So,
a long question.
Okay, I've got a few questions. Larry, what are the global precedents for POPIA, and which countries and since when? Maybe I'll take them one at a time.
Yes, I'll talk about GDPR, which is the privacy legislation in Europe and the UK. So that was implemented effective 2018. there's been one or two cases already in terms of that regulation. I think one of the big differences is that POPIA or POPI relates to both natural and juristic people, while GDPR relates only to natural people. And then in terms of things like complaints, there's no turnaround time required in POPIA. So for example, if someone goes to the regulator or someone comes to Discovery, for example, complains about some kind of incident which occurred, in the GDPR legislation, there's a 72-hour turnaround time in terms of response. In POPIA, there isn't. But I think in the main, the POPI Act has followed a lot of the principles that have been embedded in GDPR. So certainly from a European and a UK perspective, there's the GDPR legislation, which I think has definitely taken the protection of personal information definitely up by quite a notch. And we'd like to see, I think what's going to probably happen in South Africa is that we're probably going to follow suit in terms of that. In the US, I think there's quite a number of pieces of legislation, I'm not sure what they are offhand, which intend to try and protect information and people's privacy. And then in South Africa, as I said earlier on, in terms of the sister acts of PIA and POPIA, or the Promotion of Access to Information Act and POPIA, certainly, as I said, those work together in terms of protecting and accessing information. Peter, anything you want to add to that?
Yeah, you'd be familiar with HIPAA in the US, in the Canadian, North American space. As Larry mentioned, in the US, pretty much federal and state laws, of which HIPAA would probably be the most familiar. Also the California Consumer Protection Act. But globally, GDPR would be considered almost the gold standard, and most of the acts or privacy legislation are derivatives of GDPR, as is POPI, also a derivative of GDPR, but with some nuances within each of those particular jurisdictions as well.
Thank you. And then to Peter and Larry, could you sketch out very broadly the requirements as it would impact on private and public hospitals?
Sorry, just repeat the last part that broke up.
Private and public hospitals. So we got some hospital managers on the webinar.
Okay.
So I'll give you my view just in terms of hospitals in general. So again, when you go to a hospital, you've got to fill out those forms again where they sort of check you in, so to speak, for whatever procedure you've been admitted for. And again, within the hospital networks, there should be privacy statements included in those, I'll use the word registration documents at the hospitals, where you as the data subject consent to the hospital to share information with practitioners or other parties in terms of the information relating to you as the data subject, because the hospital may obtain information about you, which is critical to share with other doctors or nurses or other role players in the hospital environment. So for me, the importance of that kind of registration document and the patient consenting to that information being shared is so important. Because if there's not that consent, then the question would arise, how do you then hand over information which the hospital may have acquired to other parties, whether they be doctors, nurses, etc., without potentially upsetting the data subject by saying you had no right to share my information with those other role players.
And remember, POPI applies to any public and private body. So the government is also subject to POPI legislation.
Could you speak a little bit around the challenge of language and literacy in terms of, say, the initial registration and trying to explain privacy, all of those?
The information regulator has been very active on social media, showing their, I can say, they reach out to rural areas and a number of other outside of the city areas, outside of the main centers, in terms of spreading the word around privacy. So you can follow them on Twitter, on Facebook. There's a lot of activity that the regulator publishes. They have said to us that they are going to try to open regional offices I know there's been some challenges around resourcing and budget, etc., but they are trying to make sure that the word gets out. Not just in terms of education, but I think on the bad side or the flip side is also to make sure that they are seen as being active when their breaches do take place. So the regulator was very vocal around the Experian breach. More recently, also very vocal around the WhatsApp privacy policy changes. So they do try to get the word out as much as they can as well.
Could you elaborate?
So the challenge we have in South Africa is really how do we communicate privacy statements and understand in simple and clear language. So I do think it is a challenge.
So you're sitting in the practice, you get a patient who presents and that patient is illiterate. Could you just explain the practicality of how we could deal with that?
I think that the practice manager or the receptionist or the person who then register that patient into the practice will then have to explain to that individual what's included in the privacy statement. And again, the challenge is to keep it relatively simple, but not leave out critical information when communicating that. So it would probably be a verbal communication, probably in the vernacular that the person would understand, but then there would have to be some kind of signature to acknowledge that that person has consented to that sharing and the practice's role and way of protecting information.
And then that engagement will have to take place in a private space, because there's going to be a lot of talking involved. So,
correct.
Yeah. Okay, I see there's a question in the chat. Charlotte?
Yes, there's one more question. Thanks, Dr. Gqeberha. In the event that the practice close, Larry, is there any specific policies that should be applied in that case?
So first of all, I suppose it depends if it's sold to another practitioner. So if it's sold, then it would be the transfer of that information securely to that new practitioner. If the practice closes, then for all intents and purposes, that information and it's in essence, it's going nowhere in terms of that practice sort of disappearing. Then for me, by rights, that information needs to be, when the practice does close, de-identified or deleted. Because in essence, there's no longer anybody to be responsible for protecting that information.
I think that's an important question, Larry, because I think in the initial agreement that's signed, then maybe we should include a clause that in the event of the practice being transferred to another doctor, then the patient consents to that information being transferred.
Yep.
We should cover that.
Yeah, good point.
Yeah, exactly. And I've seen examples where the practice alerts the patient, please come and fetch your files if you want it. Unless you don't come back to us and say in a certain set period, we're going to destroy that. So those are some of those examples I've seen. Or come and collect your files, or such and such doctor is now taken over from us. Do you consent for us to have those records then transferred? Because under POPI, the definition there is this is special personal information. So it's very sensitive information and needs to be handled obviously with the due care, where we do insist on having the consent from the patient or the data subject, as we refer to it, to have that information then explicitly, give that consent.
Thank you. We've got Dr. J. Manny, CEO of McCord Eye Hospital in Durban. Dr. Manny?
Thanks, Jeff. Can you hear me?
Yes.
All right. So just from a government hospital perspective, I'd like you to comment, please, on requests from lawyers for information on behalf of patients, and specifically patient files or patient notes, please. Thank you.
Did you want to take that from a PIA perspective?
Yes. So lawyers would either use one or two avenues to access or request records on behalf of a third party or etc. So they could either subpoena. That's what we typically see for subpoena of records that would come through. Alternatively, they can choose to use the avenue of what we call a PIA request, or promotion of access to information request. So on your website or on your, you should have access to information manual. And in that manual, it dictates the steps that a requester must follow for asking for information. They would then complete what we call Form C. In our case, it's a public, it's a private body. I can't recall exactly, but it's very similar for a public body, a form that they have to complete, stating the reason for the request, on whose behalf they're doing, provide the necessary identification, the reason for the request. They have to state the right that they need to protect. And there's also usually then supporting documentation that will accompany that request. That request is then handled by the information officer or the legal department, depending on who that typically goes to. And that will be reviewed, and you've got a 30-day period to respond to that particular request to make sure it's lawful, identity has been proven sufficiently, we have the records on available, etc. So then we would review that. A response would then, after that 30-day period or sooner, go back to the lawyers to say, yes, the records are available, or you can also decline the request. And the POPIA Act outlines a number of areas that you can use to decline the request. But those have to be obviously valid reasons for that decline. And then there are other stipulations around health records that requires the person who's requesting the information to make sure that before they disclose it possibly to the patient, that there's sufficient support to interpret those results or those documents. Should the patient, say for instance, not be aware of HIV status, oncology, or other mental issues that may need some assistance in terms of interpreting those records, that has to be provided before you can actually release those documents to the lawyers as well. So that at least you cover yourself, that it should, in the event of further self-harm or other negative effects, can also be mitigated when you do disclose that record. So there is the Act prescribes it for you completely, via manual, form, etc. It's all there.
Are you happy, Dr. Manny? Thank you. Charlotte, I see a statement by Dr. April, but towards the end, there's a question. Maybe you want to...
Yes, yeah, I think, Larry, the comment was around the admin that this would add, and just who would be policing this.
Yeah, so just to answer the end of the question first. So the regulator, the information regulator, is in essence the government's policeman to ensure enforcement of the Act. As Peter was alluding to, in terms of resources and capability, they're going to be pretty stretched in terms of trying to potentially handle all the different issues that may arise once the Act's fully enforced. But I think just to maybe comment in terms of the first point that Gavin made, just around that it's a minefield. So that's why we put together, in essence, this 10-point plan to say, yes, when you first see it, it does seem like it's quite overwhelming. And there is a lot of stuff to consider, and there are quite a lot of nuances to also be aware of. But I think the main thing is, as I said, to think about the Act from a principles perspective, to go in with a philosophy that you're doing this because it's the right thing to do, and then just put some of the key fundamental pieces in place: the information officer registration, the privacy statement, the registration form, and then things like updating your patient records. Make that part of your practice in terms of good governance. Your security around your computers, just check that out. So I think there's a couple of key things to do. And if you can get those done, I think you can sort of feel far more comfortable than worrying about every element of the Act in terms of things like marketing and other elements which we haven't even covered tonight. So one piece at a time, you know, the cliche, one bite of the elephant at a time. So do a couple of key things, and I think you should be able to feel that you're kind of then on the road to compliance.
Thanks, Larry. In terms of the practicality at the reception desk in a practice, so say staff are working with a file and they place that closed file on the reception desk, and of course many practices have a register as well, which is open with the names of the patients that are there for the day. So anyone standing on the other side of the reception desk could see that. Could you speak about the legalities around that as in respect of POPIA?
Peter, do you want to take it? I see you nodding there before I comment.
I've seen many of those examples at pharmacies, at doctors. It's all over. So the responsible party or the practice has a duty of care to make sure that the information that they process or work with does not fall in any unauthorized person's hands. So you can argue then that anybody that glares over the counter or looks over is essentially an unauthorized party because they shouldn't have access to that information. So what we recommend is make sure if it's practical, because I do understand that some of the ergonomics and how the desks are set up, etc., at receptions are not always the friendliest, but the receptionist should actually, close the book, or at least when she's away from the desk, maybe just lock it, because we've seen people take photos out of visitor books and use their data. So you need to also look at it practically and say, how can we just put an easy measure in to either cover the book, lock the book away when the person goes to the bathroom or takes a break, and not at the desk, but look at it practically as well, and to make sure that, it sounds silly, but almost think like an information thief who can go into the dustbin and retrieve records that's still legible and usable.
Just to add to that,
sounds simple. Yeah.
Often you go into any kind of business and they ask for your name, your surname, your ID number, your cell phone number, your email address, etc. I think those needs to come to an end, because if you think about it, that's a treasure trove of personal information just in a nicer list. And we've got to start asking the question, like, why would you want that information? What, if that minimality principle, what is it adding to the engagement you're having with that particular type of practice or business? And the truth is that for most people, that they don't need to know your ID number. They've got to ask the question, so why do you need to know it? So those sorts of things which I think we need to start considering in terms of when we are asking for information, why are we asking for it, and do we really need it? And if not, then in fact you can also streamline your processes. Say to someone like, yes, we may want to know your name and surname, but do we need anything else about you really? I know with COVID there were all these issues about contacting the person. So maybe then you could use a cell phone number, but you don't need the person's ID number, surely, unless there's something else which is sort of you're going to need it for. But it's those sorts of, that kind of thinking, I think, which we need to start putting in place.
I don't see any other questions in the chat. And I'll ask another question. In terms of emails, we often CC people on emails. Could you speak about that?
Yeah, so I think the principle is you need to have that policy to say, what do you do when you send emails to the recipient, the intended recipient, as well as CC people? So CC people are actually intended recipients. They're not like random people you've just sort of chosen to send information to. So again, one needs to say that you need to consider, and I'll tell you what we've done, for example, with our brokers, just to give you an example of how we're handling this. So what we've done is we've said, if a member gets, let's say, a membership certificate, and they are in the to line for that email, they will then get the membership certificate encrypted, which they will then decrypt with their ID number. But the broker who is CC'd on the mail will then get that same communication in their secure inbox. So by doing that, you're saying when the broker goes in, they won't have to decrypt that communication. They can open it up, but it's in a secure place. So the principle is such that just as the to person needs to have secure communication, so should the CC person have a way where that information that they're receiving is also protected and not accessible without some kind of sort of, let's say, gateway, which would either be, in the case of our brokers, as I say, they log into the broker zone, or in the case of the member, they'd use their birthday to decrypt when they're in the to line. So yeah, so Jeff, when you CC, I think you do need to consider the protection of that information, how it's been secured as well.
I think
And you can look
also,
at, do you have keys and encryption keys, but it can get very technical and very clumsy as well. So you need to think, how can you protect that information as to the best of your ability?
and so I think it basically means, you know, CC only if absolutely necessary.
Correct.
Yeah.
Which I think many people would appreciate, actually. I think many of us feel we get too many emails every day where we copied and you kind of go, well, what must I do with this? And then people say, didn't you see my mail? And you say, but I thought it was for information purposes only because it wasn't to me. I was CC'd, you know, and people have different expectations of what you should have done with that email.
But what we have found is one of our biggest, I can say, challenges is people incorrectly CCing or sending an email to someone else that wasn't the intended recipient, because the email is very similar, might forget a little dot in between, or a 3 looks like an 8, or you know, something like that. So it's always just to make sure that, and very careful to make sure that the email address of the recipient is typed in correctly, so that you don't send the wrong claim statement or the invoice to the invoice to the wrong person. And that's always been a challenge for us.
Thank you. Charlotte, do you pick up anything on the chat?
Nothing anymore, Dr. Govender. There was just a comment around ID numbers being required by medical schemes as well. And Peter has nicely put a comment in there to say that, yes, that is information that if it is required for a specific purpose, that is obviously something that you could obtain then.
Thank you. So to Larry and Peter, many practices have the filing cabinet in the reception area. Is it reasonable for the filing cabinet to be left unlocked during the course of the day instead of locking every time after you take out a file?
I'd say yes, provided that there is always someone in reception to protect those filing cabinets and they're not left unattended. And that they should be locked at night and then opened up in the morning again by designated responsible parties in the practice. But, you know, again, I don't think that we want the Act to start like forcing people to build new rooms with 17 locks and codes and that kind of stuff. It's really, the intent is, again, just to say, we want to protect your information, that the ability of people to go in and extract a file without permission is limited. And I think each practice needs to look at potentially its layout, but that at least there's always someone, if the cupboards aren't locked or those cabinets aren't locked, that there's always someone, in essence, guarding that information.
So Larry, you might have covered this. So this would require each doctor to have a specific agreement with his staff now in terms of this act. And
yeah, so from an employer perspective, I mean, I didn't bring that in because just from a matter of time, but absolutely. The contracts, and certainly we've seen a discovery over time, we've brought in POPIA clauses around the expectation of employees to protect the information which they are, in terms of the role they're playing on behalf of the broader responsible party. So yeah, so you're right, it's a very good point in terms of re-looking as well at employment contracts and what clauses those contain.
In practices, we created, many of us have created email addresses for our staff, and very often it's Gmail addresses with the staff name. In terms of the Act, can we still use that, or do we have to change all of that and create practice email addresses?
No, you can still use that. So remember, the Act doesn't say only use this email address or only put this type of security. It's a principles-based Act.
Right.
So it talks to making sure you've got reasonable and appropriate measures in to manage the risk ultimately. But it doesn't go and say, no, go and change all your Gmail addresses or your, sometimes some of those platforms are managed much better than a smaller IT shop would be managing some of, some small little outfit, not to say to generalize, but, you might get a better service and secure service out of some of these big platforms as well. They spend a lot of money in terms of security and making sure everything is up to scratch. But ultimately, what we're saying is don't not just go and throw everything out because of the Act. Just maybe look at it a bit more, fresh eyes around a privacy perspective. Would I feel comfortable if I would share my PIN number with Larry and say, Larry, please keep my PIN number safe? It's a level of trust that I need to build. And similarly to a patient providing their data to us as Discovery, we want to make sure that they can trust us with the information that they give and hand over to us, and that we don't sell it, we don't flaunt it in terms of security, but we do take appropriate measures to make sure it's secure.
So sorry, I'm just going to ask the last one as a follow-up to that, and then I think we can move to closure. I've allowed the discussion to go on because it's so important. So you set up these email addresses for your staff, and then you use it to communicate practice information, but they use it also for themselves. So if you if the contract with the staff terminates and the staff moves on, then your practice information sits in their email. Do you have the right to close that, or does that create a scenario where you should actually set up separate email addresses so that you can actually retain it?
That's the preferable way to go.
Definitely.
Yeah. So even where you send or use your mobile device for private communications, there's messages being sent, and to your point, what control do we have as an employer over the information that's now being shared on those platforms? How do we make sure that if the phone gets stolen, the employee resigns, what control do we have or recourse do we have once that person has left? Because it's their personal properties. You can't really go and invade that. So it would be preferable to have dedicated email addresses set up for the practice alone. And we've got a policy: keep your private emails out of the business emails. Have your own personal email and use that for that particular engagement. Of course, there are going to be some exceptions where people do use their business email for private communications. We all human. We do telephone calls, private as well as business. So also just be reasonable and say, we have a practice email. We only do practice communications over that email, those accounts, so that at least there's control once the person leaves or something happens.
So yeah, I think that also brings up the point that that's also a key point to include in your contract with staff, in terms of how emails will be managed, and in terms of termination of contract, what will happen. So it's covered. Okay, so I think we've had a very enlightening discussion, and a really thanks to Larry, Peter, Charlotte, and Anand for and taking hands with us to present this very important discussion. And of course, thanks to Morris for giving the first green light for this to happen. I'd like to thank everybody else who have assisted. I'm not sure if Discovery would like to say anything before I ask Dr. Sean Falkman to do the vote of thanks.
I just thank you for the opportunity to be able to share and to engage with everybody on the call, the webinar.
Anand, would you like to say anything, Anand? Just to...
Yes, no, just thank you, and thanks for giving us the opportunity. And yeah, we will engage further, and if there is any questions, I'm just a phone call away. Thank you.
Charlotte? Thank you.
Thanks, Dr. Governor. Thank you again for the opportunity, and to the audience for being so engaging and raising all your questions. It was lovely spending the time with you. Can we please also ask if there is any feedback, how useful you found the session, or if there's anything you feel that we can improve on, to also share that with Dr. Governor and Anand. We always appreciate the feedback. Thank you.
Thank you, Charlotte. And then I'm now handing, and Pamela, would you like to say anything before we go?
Thank you very much, Doctor. Really appreciate the opportunity, and thank you to our colleagues that have embraced this opportunity, and good night and good evening to everyone on the call. Thank you.
And thank you for joining us, Pamela.
Dr. Govender, sorry, just maybe a loss. I see in the chat a request for the templates again. We will definitely share those with you, and then if you don't mind to please just circulate amongst the attendees. That should be a little bit later on in the week that we will get that out to you as well.
Thanks very much, Charlotte. Sean, it's over to you.
Okay, before I do the thanks, I'd like to urge everyone on the Zoom call to please ensure that they've clicked on the links to the Google documents for the register so that you can get your CPD points. Also, we've tried to take a backup register just in the behind the scenes, but we can't identify some people. So please give your phone a name, your full name, because there are some names that we can't identify at all, like iPhone and Huawei Y2018 and Hubley 66. So please give your phone or device a name so that you don't lose out on your CPD points. So on behalf of ECIPA Healthcare, a big thank you to Larry Borowitz. Sorry for thinking that you were a karate expert earlier.
It's fine, no, don't worry, it's good. But you're right, Lean Six Sigma is a proven methodology. And there's different levels. They've decided to use the karate bandings for that.
All right. Peter van der Walt and Discovery Health for making us a bit wiser about the POPIA Act, something that is fast going to become a reality for all of us, and also add to our administrative burden. We wish you a good night and enjoy the rest of the evening. Thank you. All right.
Yeah, thank you. I see Dr. Inchlizio has got his hand up. Do you want to say something, Dr. Inchlizio? Sorry, I didn't want to.
You haven't really clarified about how we are registering about the CPD. It's not clear.
Basically, Dr. Falkwain has on a few occasions indicated that in the chat section, he posted the link where you click on there to complete the register. So Sean, can you just paste it there again?
I'll send it again now. In the chat section, Dr. Nshona.
Inchlizio.
Just click on the link. Oh,
in the chat section. Yes,
yes.
yeah.
Dr. Inchlizio.
Yes.
I've sent it to you via WhatsApp.
Okay, that's fine. I got it.
Okay.
All right.
Good.
Thank you.
Thank you, everybody. Bye. Rest well.
Thank you. Bye-bye.
Thanks, Paul.
Bye-bye.
Really appreciate it.